Hi, this is Cesar Rowland, Public Information Officer at the Department of the Clerk of the Circuit Court here in Chicago. Today, you will learn about protective orders from our office experts who have years of experience with filing and processing these orders. We look forward to always serving our constituents in the most effective way. I now present to you Mr. Samuel Williams, Associate Clerk in the Family, Chancery, and Traffic Bureau. Thank you and enjoy the presentation.
Thank you. I hope that everybody's doing well. My name is Sam Williams. Thank you, Caesar. Sam Williams. I'm the Associate Clerk of the Family Chancery Traffic Bureau for the Clerk of the Circuit Court, Iris Martinez. So we have a very important presentation for you all today. Hope that you can get some well spread information here that we're going to spread out to you all and give you this information that you can have with you and know as you go on through these days and out in the streets, and just know what your protection availability is and what the courts and how we interact with order of protections and things like that. So for no further ado, so actually what I do want to say is we're going to have the Associate Clerk of the Criminal Bureau, which is Darice Goodwin, who will also be representing Robin Page, who is the Chief Deputy Clerk of the DV Courthouse, who will also be with us today. And then, of course, our esteemed Executive Clerk of Court Operations of the entire Cook County area Court Operations, Carmen Navarro-Chacon. And she will close us out with a series of questions that she has, just a small number of questions to kind of help us understand the process even more. Okay, so I think we want to get right into it, and we hope that this is very helpful for you, and we hope that this is something that you can definitely take with you. And you could always, of course, get a hold of us, throughout the week here at the Clerk of the Circuit Court. Okay. So I will, hopefully we can see that. The Office of the Clerk of the Circuit Court of Cook County, Iris Martinez, advocating for victims of violence. And this is the month of February 2023. So I want to already, again, our panelists, Darice Goodwin, Robin Page, and then Carmen Navarro-Chacon. And then I am Samuel Williams, your moderator of the Associate Clerk of the Family Chancery Traffic Bureau. Okay, and so since we're talking about protective orders, I want to go through some frequently used terms so that you are aware of some of these terms and what they mean. So here are some of the terms that are frequently used throughout the court system. We do understand that some of this language may be, a little bit much for others to quite understand. So that's why we do like to have plain language to kind of help people understand what they are dealing with. So civil court handles legal disputes between two or more parties. That is just basically what civil court kind of means if you hear that. Criminal court enforces criminal codes and laws. Typically, with criminal court, there may be an arrest that may have happened. So that's typically those type of things that happens in criminal courts. Summonses. Have you ever heard the word summons or the term summons? It's a notice requiring your appearance, or whoever receives the summons. It's saying, hey, you are being required to appear before a judge on this date and this time, location. That's pretty much what summonses usually have that information on it. The order is a term that is used in courts daily, and that is typically a command or a direction or an instruction issued by a judge. So when you say that the judge ordered me to do something, or the judge ordered someone to do something, that's just basically what it means. It's something that they are entering in the court through a hearing and commanding or direction or instruction that they want the defendant or the plaintiff or respondent. You'll hear those terms as well. Petition. Well, they're court forms that are filled out to initiate a court proceeding. So basically, I like to let people know that a petition basically just means a request. It's you're coming in and I'm filing a request or a written request, or whether it's electronic. Now that we have an electronic basis, requests to initiate a court proceeding. Remedies. Remedies are resolutions listed in the court order by the judge. So basically, they're resolutions or solutions or something to that the judge says. You know, these are some of the things that are listed on this petition or in this court order that you will that we will need to abide by. Leads is exactly that, what you see: law enforcement agency data system. Okay, and so that is what leads means. That is what the state of Illinois, that is kind of the system that we use, or the terminology that we use for any order or order protection for the most part that is entered into the system. It is entered into leads. And leads, what it does is the data information that enters into lead feeds into this national database. So that means that any law enforcement agency, what have you, outside of the state of Illinois, could be probably even as far as California, should be able to, as long as it's in leads, they'll be able to see some information. So that's kind of the broad scale of what leads. And I know Carmen she probably expound on this a little bit more as well. So petitioner, you heard me mention that term just a few seconds ago. It's a party who initiated the case, or a party who started the case. Okay, that is the person who says, hey, I want something to be done. Respondent is a party being brought to court by the petitioner. So that is the person who has to, so respondent means exactly that. It's the person responding to the petition or the request for something to happen. So that now they have to respond to this petition, or they have the petitioner. So the respondent is the party being brought to court by the petitioner. So if you want, in terms of who's on top and who's on bottom, that's kind of how it looks. It's kind of the petitioner is on top because they started the action, and the respondent is the person that has to respond to the action that's being brought to them. Okay, all right, and those are some of the frequently used terms there. So now, what are protective orders? So this is basically what protective orders. It is an order. It is a document issued by a judge that sets legal parameters intended to protect victims from future acts of domestic violence, stalking, sexual assault, workplace violence, threats from use of a firearm, and or contact from their perpetrator. All right, so there is a little asterisk here that I want to make sure we all know this, that the individuals who have current pending cases within other court divisions, like a parentage case, a dissolution, a petition for guardianship, which is usually in our probate division, may file a petition for an order of protection as a part of their current case as well. So in those areas, it is definitely something that happens on a consistent basis, where you can file an order of protection on those case types. All right. So now the types of orders, and then the panelist is gonna expound on these a little bit more. But basically, the types of protective orders are the domestic violence order protection. It could be civil or criminal. All right. So you have emergency order protection, you have an interim order of protection, and you have a plenary. All right, and they will explain, kind of go into what those are. You have the stalking no contact order. This is typically a civil court. You have the civil no contact order, and you have a firearms restraining order. It is typically in civil and criminal courts. All right, and so those are typically the typical types of protective orders that we hear in the Circuit Court of Cook County. Now, I'm going to now pass the baton over to our associate clerk of the criminal bureau, Ms. Doris Goodwin, who's been here for a number of years as well. And she has a very in-depth wealth of knowledge in regards to this. And she's going to share with you the next steps. Doris?
Thank you so much for that, Sam. Thank you everyone who's out there joining us today. I think the most important things is to recognize here in this presentation is the desire for Clerk Martinez to assist victims of violence. And in those things we've heard the term constantly domestic violence. And I think the first thing we want to talk about is what happens when domestic violence occurs. How can you recognize domestic violence? And one of those things, or a number of things, is domestic violence occurs when any person hits, chokes, kicks, threatens, harasses, or interferes with the personal liberty of another family or household member. And so us here at the Clerk of the Circuit Court, we care about the lives and liberties of our constituents. And so with that being said, in the event of domestic violence, you are able to get a domestic violence order of protection. An order of protection protects victims from acts of abuse or violence from a family or household member, and that's covered under the Illinois Domestic Violence Act of 1986. Those persons that can file for an order of protection are spouses and former spouses, children or stepchildren of abusers, parents, blood-related and in-law family members, roommates and ex-roommates, people who share a blood relationship through a child, as well as people who have had a dating engagement or sexual relationship. Next slide, please. The types of domestic violence orders of protections are emergency orders of protections. Those are things that are granted within 14 to 21 days, but we'll get that in a little bit. Another type of order of protection is an interim order of protection, as well as a plenary. Next slide. Inside an emergency order of protection, it's a court order. Sam talked about court orders earlier, signed by a judge that protects the petitioner from harm by a person named in the order, the respondent, the person responding to the petition. An emergency order of protection takes effect as soon as the judge approves it in court. An emergency order of protection usually lasts 14 to 21 days until a plenary hearing can be scheduled. In criminal cases, an order can stay in effect throughout the duration of the proceedings. To add to this, for an emergency order of protection, it can help victims in a number of ways, and that includes, but are not limited to, prohibiting the abuser from continuing threats, barring an abuser from a shared residence, and requiring an abuser to attend counseling if the judge so deems. Next slide. Inside an interim order of protection, the judge may grant a petitioner an interim order of protection after a respondent has been served, but may not have been notified of the hearing date, or if attempts have been made to serve the petition. And this order may last up to 30 days. So this is a temporary sort of order of protection. Next slide. Last, we have the plenary order of protection, and that may be issued by a judge after the respondent has been notified with the information to appear in front of the court. Regardless of the participation of the respondent, the petitioner must be present. The person who filed the petition must appear in court in order for the plenary order to be granted by the judge. A plenary order can be in effect for up to 2 years, depending upon the petitioner's actual request. If the respondent happens to be in custody or in jail or in prison, the 2-year term can start upon their release. Last but not least, the plenary order of protection does the exact same as the emergency. However, it is more of a long-term deal. Next, for the next steps or the next slides, I'm going to introduce to you Robin Page, who is our Chief Deputy Clerk of the Domestic Violence Courthouse. Robin.
Hello, everyone joining us today. Since we discussed domestic violence orders of protection, now we'll talk about other types of protective orders. The first one is a stalking no contact order, which offers protection from acts of stalking, harassment, or abuse from individuals with a familial household relationship, which is protected under the Stalking No Contact Order Act. The people that can file stalking no contact orders are neighbors, friends, associates, coworkers, an authorized agent of a workplace, place of worship or school, anyone with a household relationship, a non-common dwelling relationship, non-familial relationship, or a law enforcement officer. Next slide. The next type of protective order is a civil no contact order. This order protects people from acts of non-consensual sexual conduct or sexual assault under the Civil No Contact Order Act. individuals, either minors or adults, whom are victims of sexual assault or non-consensual sexual conduct can file a civil no contact order. Next slide. Next is a firearms restraining order, which is also known as an FRO. A firearms restraining order is a court order that says a person cannot have a gun, ammunition, or gun parts because they pose a threat or of injury to themselves or others under the Firearms Restraining Order Act of Illinois. This red flag law aims to prevent firearm injury due to persons experiencing a temporary crisis. The individuals that can file this type of order are a spouse or a former spouse, a parent, child, or stepchild, people related by blood or marriage, individuals with whom they've had or allegedly have a child, a person with a person who shares a common dwelling with them. Next slide. Now we'll talk about steps to obtaining an order of protection. Once a case is filed with the Clerk of the Circuit Court, the petition is heard by a judge. The judge will then determine if an emergency order will be granted or denied. After the judge issues the order, the petitioner will receive a copy of the signed order by the judge. If an order is granted or continued, a copy of the summons, the order of protection, and the petition is submitted to the Cook County Sheriff's Office on a leased transmittal and/or for service to the respondent. Also, please note that orders of protections are not public record until the respondent has been served. Next slide. Next, we'll discuss how orders of protections get to the Cook County Sheriff's Office. So once a petition is heard by the court, regardless of whether an order is entered, the case is listed on a transmittal and all the documents are hand-delivered to the Cook County Sheriff's Office for service and entry into leads. If no address is available for service, or if there's no date of birth available, the sheriff may attempt to locate the respondent. They'll use means that they exclusively have to locate the respondent's date of birth or their address. They also may contact the petitioner for additional information about the respondent. If there's no date of birth listed for the respondent, the sheriff's office may still serve the order, but will not be able to enter the order into leads. Next slide. Additional remedies are mandates in the protective order that the judge can add that are enforceable by the court and by law enforcement, which include the exclusive possession of the residence, meaning that the respondent cannot come to the home and you will exclusively have possession of the residence, custody return of the minor children, the respondent being prohibited from being at the residence, and visitation parameters regarding minor children. Next slide. A respondent must have been served with a protective order before they can be criminally charged with the violation of an order of protection. If law enforcement responds to a call from a victim and leads reflects that service has been previously completed, the offender, aka respondent, can be arrested for violating the order of protection. A respondent charged with violating an order of protection or protective order may be placed on a GPS tracking system. If the respondent is charged with violating the order of protection or protective order, the victim may choose to participate in the GPS tracking program via the Cindy Bischoff law. Next slide, please. Here are a list of advocacy agency resource information. You can use this information if you are subject to any type of abuse, threats, or any type of acts of violence. And these individuals may be able to help you with, to give you legal advice, or they may be able to help you complete your court forms. Next slide. Thank you. That concludes our presentation. Now I'll kick it back over to Sam Williams.
Thank you, Robin. I really appreciate that. What I'm going to do is I'm put this back up just so you all can have this and see this information while it's there. The next panelist that I want to pull, so you all can talk with her and she can talk with you, and she can share some frequently asked questions to help you understand, this is an extremely important. I'd say everything that we do with the court is very important in various facets of people's lives. We do know that this definitely is something that's extremely important when it comes to the lives of individuals that come into our court system. Because of threats of violence, either with a domestic partner, a spouse, even a friend that you thought was a friend. It could even be somebody that it could be even a neighbor or a coworker or something like that, which is why these types of order protections and the stalking no contacts and the civil no contact orders, why they exist. Firearms restraining order, which is why they exist, because we want to at least be able to make sure that there are facets or there are components in society to be able to help people be protected. And so Carmen Chacon, she is our executive clerk of court operations. She was also formerly with the sheriff's department for a number of years and moved up through the ranks. So she has a vast amount of knowledge on both ends. So this is why I think it's very important that we also hear from her. And so Carmen, I'm going to pass it on over to you.
Thank you very much. Hello, everyone, and thank you for joining us. I wanted to share some frequently asked questions with everyone, simply because there's a lot of information that, as you heard from the associate clerk and the chief and Sam about all these orders, some of it can be very confusing, especially when you're in the midst of the crisis. We all know for various reasons, individuals find themselves in need of protections, and knowing what to ask for and where to go can be confusing. So we will be sharing this information on our website and sending it out to the resources as well that you see still on the screen. But some questions to help us kind of expound a little bit on the information that you've been provided. And these are questions that we receive via telephone or via email from advocates. We get these questions from petitioners and from respondents alike. So for example, the first question that we get a lot is, what happens if I see the respondent near my home or my work? And I asked the court to, include those places as protected addresses. So the exclusive possession remedy that Chief Page referred to, where I want to live in my home and I live at 123 Main Street, and the respondent is not supposed to be there, and I go outside and he's there. What do I do? Who do I call? Well, we don't want you to pick up the phone and call the clerk's office. We don't want you to pick up the phone and call the sheriff's office, simply because we've told you that the process comes to us and we've transmitted that to the sheriff's office. We want you to call 911 because you've gone through the steps, you've obtained that order. We've explained to you, from us, it goes to the sheriff. If there's a date of birth, it goes into leads, which means if you call 911, regardless of the city that you live in within Illinois, even if you obtain that order in Cook County, and you now live in DuPage and you have your work as a protected address, whatever the case may be, pick up the phone and call 911. If that order has not yet been served and it is entered into leads, the law enforcement agency that responds can look into that law enforcement agency database system, find that order, including the remedies that were ordered, and serve the respondent with what's called a short form notification. But for your purposes, what happens is that respondent will get a piece of paper telling them that there is an order that was issued against them, and it will instruct them as to the remedies that the court has ordered, if the sheriff had not yet served them. If the sheriff had served them, or if that individual had already previously been served with notification, the responding law enforcement agency can arrest them for violating that order of protection. So for your purposes, if it's at work or at home and you ask specifically for those addresses to be protected and you see the respondent, you do not have to figure out whether they were served or not first. You simply pick up the phone and you call 911. I don't know if Doris or Robin, if you have anything to add in addition to that.
No, you summed it up very well.
Okay, thank you. The second question you may get a lot is, what if I don't have the birth date? Like you heard also Chief Page referred to. I didn't have the birth date when I got the order, and you're telling me now it's not going to be in Leeds. And if I call 911, they're not going to be able to serve them because it's not in there. But now I have the birth date. Who do I call so I can make sure it gets there? At any time during the process, if you have an order and you didn't have the birth date at the time the order was issued, and you find the birth date later, you can contact the sheriff's office at that time and tell them, I didn't have the birth date before, I have the birth date now. You can go directly to their website, locate the number for their civil process unit, and provide the date of birth so that they now can update their records and enter that date of birth. You can also contact our office directly. Tell us that you now have the date of birth. So if you were at the Bridgeview Courthouse, if you did it virtually, whatever format you use, we will be happy to be that caveat to connect you. You can provide the date of birth, and we will provide that date of birth to the sheriff's office in the same manner we provided the order to the sheriff's office for you. So if you obtain information later, even the address, the clerk's office, per the direction of, again, the clerk of the circuit court, Iris Martinez, because this is a serious issue. And we understand that the remedies you are seeking, we want to make sure that those are provided to you as quickly as possible. So use our office. We can convey that information and send it up. So remember, any information you didn't have at the time you obtained the order, it is still possible to provide that information at a later time. And we suggest you can reach out to us, you can reach out to the sheriff's office. You can reach out to any of those agencies on the resources you're looking at, on who do I call, you can reach out to them. I have the date of birth now. They have a direct line to the clerk's office, the sheriff's office, to get that information updated for you. The next question we get, who else or what else can I protect in this order? And you may say, what do you mean, what else? In these orders of protection, you are allowed in these remedies to protect your pets. We know that abusers a lot of times use the pets as a way to further hurt petitioners. The court is aware of that. So if you have a pet, you can ask that that pet be protected. You can ask, if your sister lives with you, you can ask to protect your children. You can ask to protect your workplace. You can ask that the respondent not be allowed near the children's school. Those are all things that you can ask for in the petition that are really important. I don't know, because this is a very important question we get all the time. Doris, have you ever heard of any other things that maybe I'm missing that people have asked to be protected?
I have actually. I've seen people ask to have their children's activities protected. But if their children are in dance or cheer and things like that outside of those school functions, as well as church.
Yeah, that's very important. Thank you. Like I said, I don't want to miss any, because I know we get those a lot. People just don't know, and you may not have this with you, so that's important. Another question, how long will it take the Cook County Sheriff's Office to serve the order? That varies depending on the information that's been provided. There is, when you file for an order of protection in Cook County, what's called a confidential information that is available to petitioners, and our office can provide that for you, where you can provide any other addresses where you think that person may live, or may be, the kind of car they drive. And you can also provide your contact information. For example, if you listed that he lives at 123 Main Street and the sheriff attempts to go there and someone answers the door and tells the sheriff they don't live there anymore. Well, the sheriff may contact you to ask you, hey, so-and-so just told me that the respondent doesn't live at that address anymore. Do you know where else they may live, or do you know where they work? Because they can go to their workplace to serve them as well. So again, it depends on the information that's provided at that time. So those are some of the other addresses you can provide for service is their work. And yes, the sheriff can serve them at their work. What happens if the order is denied? This is where the clerk's office wants to provide and wants to be very careful on making sure we provide legal information, but not legal advice. So if you've completed a petition and you've gone in front of a judge on that emergency order of protection or that stop no contact order, and the court decides for whatever reason, it could be that the emergency or the situation that you described occurred 2 or 3 weeks ago, and that individual hasn't contacted you since, the court may feel that you're not in need of an emergency order, but that there's still a reason for a hearing on a petition. So in that case, the order may be denied and your petition may be entered and continued. So you may still have a hearing and the court can still enter an order at a later date, just not an emergency order at that time. Those are some of the questions that we get more often than not, and I hope help clarify some things for you. And remember, you can still contact our office, and I know Caesar, who brought us in, will take us out with some information on that as well. So thank you very much again for joining us today on this very important topic. And Caesar?
Well, I think Caesar, you're on mute. And in the meantime, I did put I wanted to make sure that you had the information again for the advocacy agency resource information on the screen again. But again, you know, we do have, I believe, through our website, you can Cook County Clerk of Court.org, that you can get this information. But these advocacy agencies are throughout the Cook County area. I know Sarah's specifically is in the west suburban, and they do operate out of the District 4 Maywood Courthouse, and you have some other areas as you see. So I just wanted to make sure you all had that on the screen to see once again. All right, Caesar.
Well, thank you once again to the entire panelists here at the Office of the Clerk of the Circuit Court. As we know, on behalf of the clerk, Iris Martinez, we are here to service you. And we also say, look forward because we have a lot of great new information coming through, as well as a brand new call center that's going to be implemented very shortly. So please stay tuned and go to our website. Not only are we there to service you, but we can also answer your questions in multiple languages. So again, thank you to all the panelists. Thank you to the constituents. And know they're here. We're here to service you. Thank you.
Thank you all.